Good morning, everyone. Am I audible? Great. I must say it's a bit intimidating to share the stage with my partners who are leaders in their respective fields. So if I faint, don't be alarmed. Lita will just carry me away. So the High Court handed down its judgment in this application in June 2023. But the factual matrix that actually relates to the application go as far back as the 1990s. I was born in the 1990s, I just won't tell you when. So needless to say, if I spend sufficient time properly navigating the factual matrix, we'll be here all day. And I must warn you, the facts and this application is very similar to the movie Inception. It's regarding an admission of an applicant in a so-called main application and a private prosecution stemming from a public prosecution. So let's get into it. So our former president, Mr. Jacob Zuma, is charged on various counts, including racketeering, corruption, money laundering, and fraud. And the lead prosecutor on his case is a Mr. William Downer. And on 5 September 2022, Mr. Zuma launched a private prosecution against Mr. Downer. The charges broadly related to the alleged unauthorized disclosure of information by Mr. Downer to Ms. Karen Moore. So Ms. Moore and Mr. Downer were summoned to appear before the court on 10 October 2022. So faced with these charges, Mr. Downer launched an application to set aside the private prosecution and interdict Mr. Zuma from launching any similar charges for moving forward. Mr. Downer and Ms. Moore therefore launched two separate applications. So the legal principles, very similar to the facts, are broad, but I thought it'd be useful for this purpose to focus on two main grounds. First, it is what is the role of an amicus curiae in legal proceedings? And second is that of prosecutorial independence and abuse of process. So turning to the first issue, amicus curiae. So an amicus curiae is not a party in the litigation that it participates in. So it's not an applicant or a respondent. Instead, it acts as a friend of the court. And Rule 16A of our court governs the admission of an amicus curiae in legal proceedings and provides that if an organization such as the Helen Suzman Foundation wants to act as an amicus curiae, it must first get the consent of the parties, and if not, it must apply directly to the court for admission. So it provides that it must show, such an organization must show four things. First, that it has an interest in the litigation. Second, that it will make submissions that are relevant and that these submissions will assist the court, and that these submissions are different from those of the other parties in the proceedings. The Constitutional Court made it clear in the treatment action campaign matter that the role of an amicus is to draw to the court's attention matters of law or fact that it would have not otherwise been drawn. So the Helen Suzman Foundation is a non-governmental public interest organization which has as its purpose the promotion of South African democracy and constitutionalism. So it has acted as an amicus curiae in matters such as the one seeking to affirm the independence of bodies such as the NPA. So in this matter, the Helen Suzman Foundation first wrote to the parties seeking their consent to be admitted as an amicus curiae, and Mr. Downer consented. There was no response from Mr. Zuma. And so the foundation wrote an application directly to the court for its admission. Broadly, the foundation sought to address issues regarding prosecutorial independence and abuse of process, and how courts can protect themselves and litigants when faced with these type of abuses. Mr. Zuma opposed the application of the Helen Suzman Foundation and that of 3 other organizations. In his affidavit, Mr. Zuma essentially said that the submissions of the foundation would not assist the court and enrich it. And we were all booked, ready to go to Pietermaritzburg, when 3 days before the hearing, Mr. Zuma consented to the admission of the Helen Suzman Foundation and that of 3 other parties. However, Mr. Zuma persisted with his argument that the submissions of the foundation should be dismissed as they lacked merit and were biased. So the court had to consider a very fundamental question, and whether neutrality is a requirement for an amici applicant. So essentially, should an amici not favor the arguments of one party over the others? And the court landed on the argument that neutrality is not a requirement. Instead, the interest of an amici must be an interest in the correct application of the law. So having dealt with the issue of admission, the court turned to the issue of prosecutorial independence and abuse of process. So whether ulterior purpose and or motive are relevant to the validity of a prosecution. And if so, whether such a private prosecution constitutes an abuse of process. So to take a step back, what is a private prosecution? So me, Thandiwe, I go to the police to lay a charge, well, a complaint against Lita for stealing my pen. The state considers my complaint and decides not to prosecute and issues what is called a nolle prosequi. I'm still aggrieved by this decision not to prosecute. And what I do is that I can conduct and institute my own private prosecution. So I take the role of a public prosecutor, for example. And the benefit of this is self-evident, especially in a country such as ours, where our faith in the criminal justice system is not particularly very high. Now, prosecutors appointed under the NPA when performing their functions, they must do so in a manner that is without fear, favor, or prejudice, and they must do so in good faith. And their independence is safely guarded in our law, because it's of course accepted that their independence is directly related to their ability to perform their functions. Now, private prosecutions, such as Mr. Zuma, do not have the same structural constraints that public prosecutors do. So the question then is, what must happen when a private prosecution is pursued not for justice, but for another purpose altogether? In this matter, the Helen Suzman Foundation argued that when one considers the conduct of Mr. Zuma itself, so him instituting the proceedings and the conduct of him after instituting the proceedings, it was quite evident that he was not pursuing these charges to bring Mr. Downer to justice. Instead, he was pursuing these charges to rehash the claim that there's a political conspiracy against him. So the foundation considered the witness list, for instance, which included Mr. President Cyril Ramaphosa. It included Ronald Lamula. It included Mr. Hofmeyer, who was the former NDPP. It included Mr. Muhaswa, who was the former public protector. These people were completely disconnected from the charges that Mr. Downer was asked to answer to. Secondly, when one considers the substantial statement of facts, it didn't include matters that directly related to these charges of this unauthorized disclosure, but instead it was this political narrative regarding the charges Mr. Zuma himself was asked to answer to. So the true purpose, the foundation argued, was to, one, hinder the prosecutor that he was prosecuting him, Mr. Downer, so to intimidate him and harass him in the performance of his duties. And second was, as I said, to rehash the claims that there was this political conspiracy against Mr. Zuma. The court agreed with these submissions and found that this prosecution was an abuse of process and set aside the private prosecution. It dismissed the arguments that were raised by Mr. Zuma that there will always be recourse that Mr. Downer can have at the end of the trial, for instance, in terms of costs. So this matter strikes directly at the rule of law, which is a fundamental value of our constitutional dispensation. And our country knows too well how the criminal justice system was used to silence, to intimidate, to get rid of people you disagreed with. And a private prosecution is such a powerful tool. And if you consider it, it can be used very similar to how it was used. It can be used to harass your noisy neighbor. It can be used to silence a journalist. It can be used to bully a business competitor. And it can be used to get rid of a public prosecutor. So the judgment is important in asserting the very simple principle that power must be used for the purpose of which it was given.